Rule 110. Prosecution of offenses. Under it is the institutional of criminal action. It means filing a complaint or information to those person commit an offenses or criminal act. And a complaint is a sworn written statement charging a person of an offense subscribed by the offended party, police officer or any public officer. And information is the accusation in writing of charging a person of offense subscribed by the prosecutor and filed with the court. And in filing an information pursuant to Rule 112 requiring preliminary investigation, and now hereby amended to the Department Circular Number 15 to those offenses punishable by 6 years and 1 day above, it must be filed to the Office of Prosecutor and conduct preliminary investigation. And to those offenses 6 years below must be filed in the municipal trial court or what we call direct filing. Rule 111. Prosecution of civil action. In Section 1, when the criminal action is instituted, his civil liability shall be deemed instituted. That is a general rule in this rule, but it has exemption. The first exemption is the offended party waives the civil action, and then second is the offended party reserve the right to institute it separately, and the third one is the institution of civil action is prior to criminal action. Rule 112. Preliminary investigation. According to the Section 1, preliminary investigation, it is an inquiry or proceeding to determine whether this is a probable cause to the crime must be committed, and then preliminary investigation required to be conducted before filing a complaint or information which have penalty of 6 years and 1 day imprisonment. Rule 113. Arrest. In Section 1, taking a person into custody and in order that he may be bound to answer for the commission of an offenses. And then, in the Section 4, the prosecution of warrant within 10 days. Then, after the period of the prosecution after the period of the judge after a period of prosecution of warrant within 10 days, the police officer shall make a report to the judge in case of failure to execute the warrant. The warrant. And then police officer shall state the reason in Section 5. Police officer can arrest a person without a warrant. First is in flagrante delicto or caught in the act, and then the second is hard pursuit or personal knowledge, and the last one is escape prisoner or escapee prisoner. In Rule 114, bail. Bail is a security given for the release of a person in custody of the law, furnished by him or the bondsman to under the condition a bondsman to guarantee his appearance before any court as required under the condition of under the condition of hereinafter for the specified or kuan. And then according to the section 2, all person can avail of a person have an offenses can avail to bill except to the people have an offenses punishable by reclusion perpetua, death penalty, and life imprisonment. And then instead in section 4, bail is a matter of right, and before conviction by the municipal trial court, metropolitan trial court, and municipal circuit trial court, and before conviction of the regional trial court, not punishable by LDR or reclusion perpetua or death penalty or life imprisonment. And then Rule 115, right of the accused. The accused in the criminal prosecution have several rights, including the first is presumption of innocence, second, right to be informed nature and causes of accusation, and then the third is the right to present and defend himself, and then the fourth is the accused can testify as a witness on her behalf, and etc. Rule 116, arraignment and plea. Arraignment, the accused must be arraigned in open court by the judge or clerk. Plea, the accused must enter the plea of guilty or not guilty or nolo tender. Rule 117, motion to quash. It is a written motion filed on the accused to challenge the validity of the criminal complaint or information. And then in Rule 118, retrial. Pretrial is mandatory in criminal cases, which is the reason to avoid surprises, and in pretrial, both of the party may lay down all the evidence, witness, and failure to present those on a pretrial or could not be admitted to the trial otherwise for the good causes, then the pretrial there will be a plea bargaining, disclosure of facts, and marking and identification of the evidence, waiver and conjunction, and then the last one is the mandatory of the order of the trial with the accused admit his charges. Rule 119. Time to prepare trial is after a plea not guilty entered. The accused have 15 days to prepare for the trial, and then the trial shall commence within the 15 days from the receipt. Pre-trial order in section 3 stated there that delay of the trial shall be excluded in compiling or in computing the time within when the delay or other proceeding concern the accused. Delay resulting from mental incompetence, physical inability, and if the accused cannot stand in the trial, if the information dismissed upon motion of prosecution. And Section 2. The order trial must be present the evidence to prove the charges the accused and the accused of the defense have a rebuttal and rebuttal for evidence shall submitted for decision. Rule 120. Judgment. And Section 1. Judgment is adjudication by the court that the accused guilty or not guilty of the offenses charges, proper penalty and civil liability. In Rule 121, new trial or reconsideration. In Section 1 of the rule, new trial or reconsideration may happen anytime before the judgment of the conviction becomes final. And then in Section 2, a new trial or reconsideration becomes if there are error of the law, and second, there's a new material evidence has been discovered. And in Rule 122, appeal. In Section 1, any party may appeal from the judgment or final order, unless the accused may be placed to double jeopardy. And the Section 2, where the appeal first level, which the court is the MTC, when from MTC go to RTC, from RTC go to the Court of Appeals, and then Court of Appeals go to Supreme Court. And Rule 123 is the procedure in municipal trial court, and then the Rule 124 is the procedure of Court of Appeals, and then the Rule 125 is a procedure in the Supreme Court. And Section 126, seize or seizure. In Section 1, the defined of the search warrant as on order in writing the name of the people of the Philippines, signed by the judge, and the directed to the peace officer recommending him to search for personal property described therein and bring it before the court. The personal property to be seized according to Section 3 are subject of the offenses embezzlement, property and use, or intended to be used as and the means of the committing of the offense. And then in Section 7, police officer must be identify themselves and announce their purpose before using force to enter. Apply first the break and announce doctrine. A warrant must be served in the day, unless the affidavit indicates the property is on a person or place, in which place it can be served at any time of the day or night, found in Section 9.